Welcome to the bold analysis. The reason behind the hybrid system of electoral process in Kenya being integration of the manual and the technology was to reduce what was a plan in this country of using electoral fraud as a tool to perpetuate authoritarian rule or cling on power. And I want to put this to a context that the integration of technology and the manual was actually developed by the framers of the 2010 Constitution that came up with the Election Act of the 2011. The 2010 Constitution is touted as one that was the most progressive because it came after one of the lowest moments in Kenyan history in 2007, where there was election robbery in daylight when Raila Odinga was rigged out by the late President Mwai Kibaki. And I want to say that the Supreme Court did a disservice to the framers of the 2010 Constitution, because the African presidents for over time have been using means to manipulate elections, or rather manipulate numbers and extend their term in power. And I can tell you that you will see them lauding the design that was used in the Kenyan election in the August 2022. While the framers of this hybrid system envisioned this integration to restore order in our electoral system so that the winner takes it, it is so unfortunate that the real intention of the technology has actually not been achieved. In 2013, that is we first used technology. It was disputed. The William Tunga bench upheld President Uhuru Kenyatta's election. In 2017, Raila Odinga went to Supreme Court, and William Ruto's and President Uhuru Kenyatta's win was nullified, even after what many people saw was an authoritarian decision by the commission not to access the servers. Kumbuka the issue of the servers. And in one of the latest reviews that I have taken by some few lawyers who are members of this channel, and also reviews by a website that I should share with you. It's a very interesting website by one of our subscribers here, and I want to just get an article. It's called the Jade's blog, Technology and Electoral Process in Africa. So you can visit his blog. It's called Jade's blog. The website is kanimoni with y.com stroke blog, but I think if you just search Jade's blog, you will find it. It's an article, Kenya is not ready for the electoral technology, and you will get very interesting insights into this. And one thing that comes out is that Mother Koome-led bench did a disservice to Kenyans. And I want to be very objective by saying, not to mean that they had to nullify the election for them to do the service. But the challenge is, while the hybrid system, the framers of hybrid system, touted it as a cutting-edge solution or one of the best models or designs to make sure that our process is tamper-proof, But due to the evolving technological advances, you cannot we cannot underestimate that this hybrid system is also infiltrated. And as years go by, I can tell you that it will be morphed up to other forms. In 2017, we didn't have portals. But after many KK said that the results at polling station are final, we later came and now had a transmission where it was taken directly to a portal. And even at that, still we had a disputed election. And this can be seen as a defense of, or rather defending Azimio. But one thing that has come out is that it was and it is extremely difficult to extract such a tangible evidence that is based on technological flaws, on the digital flaws. It needs more advanced, and it needs time, and even you can have an evidence, but it also needs a capacity. It also needs the arbitrator, the judges, to have inside look and be in a position to understand every other thing. A good lawyer of mine, a friend of mine in this channel, asked me a question. It was easy for Mother Koome to say that what Azimia presented was hot air. And vis-a-vis, it was just a mention of what Azimio, the relief Azimio said, and what the IBC said, and the judges picked what IBC picked. Why is it that they could not question what the Azimia side said? But then to some, they mentioned that there is no evidence. Was it that there is no evidence, or the evidence is difficult to interpret? Ladies and gentlemen, I want us to look at this in a very interesting manner, because it's a very interesting article and it's a very interesting revelation from what exactly we are dealing with. And if that is going to be the precedence that we've set, next time when someone is having, will it be easy for regime of the day to perpetuate its rule through the digital fraud, through the electronic fraud, simply because it has now become extremely difficult to defend yourself before a court with an electronic, rather than with electronic evidence? While it was easy to speak about the logins, the maintenance allegations, it's easy for a layman to understand about login details, copyright issues. It's easy for someone to understand issues like this. I want to get it. Logging and maintenance allegations, the issues about where the forms changed, there are things that you can easily question. But there is something that I want to believe the Supreme Court needed to have looked at. You cannot give a clean bill while all those allegations, because even the judges, and not even the, I think even at some point, in one of the rulings previous day, I think some few after the general election, a judge mentioned that we needed to have the manual register because electronic system is not 100% efficient. But according to the Supreme Court judges, it seems it was 100% efficient and there was no problem. Even though efficiency can be measured in terms of percentage, the percentage efficiency. This is the gap. The framers of the hybrid system did not envision the fact that the electronic system can be compromised. And this is the threat that such kind of a situation poses to electoral system. My votes don't count feeling starts to crop in. And in other words, you can call it voter apathy. Actually, in this election, there was voter apathy. And one of the causes of voter apathy was my vote don't count. Now, to that extent, I'm not saying that people did not, the issue of my vote did not count. Remember, at as people were heading to the election, there were exchanges from both political divides, while Kenya Kwanza were blaming Matiang'i for using the chiefs to infiltrate, or rather to interfere with the polls. To their Kenya Kwanza, that was already a feeling telling the fans that, look here, my vote don't count. On the other side, this was coming at a side when Raila Odinga was also coming from an election that my vote don't count as emerged. Coupled with the high standard of living, Mr. Voter realized that maybe my vote did not count. And quite a number abstained from the polling stations. Now, by this voting narrative, rigging narrative, it has now emerged that Raila Odinga team have insisted that yes, we respect, but we don't agree. And their stand was on rigging. In the next subsequent elections, it is so bad. I don't want to be an agent of prophet of doom by agitating for what many people have said, that I am not going to vote. I think you still need to vote because it is your democratic right. But quite a number, when I go through the comment section in my channel, I realize many people are saying, Kevin, I'm voting for the last time. I remember a woman, I think one of subscribers traveled all the way from US and came to the country, and she was supposed to vote, I think, in Migori. Then the day before, she just, after landing in Kenya, she just realized that something has happened and she was no longer in the register. Remember, these are things that happened. So next time, will someone fly from US and that diaspora, maybe to vote in the country? And remember, there are some countries where people, the voting has never been done, as in they're not part of the diaspora constituency. I remember the lady is not from, I think she was from Sweden, if I'm not wrong. So, the my vote don't count feeling is still here with us. Whether it was to nullify or to uphold, but at least the Supreme Court would have given a glimpse of hope on just questioning the electronic issue system. Because with giving it a clean bill, it actually deflates any electoral reform push. And I just want to ask a simple question. We have a shrinked opposition, yes, and the civil societies can swing into action and offer opposition and reform agenda in this government. Remember, we had a reform ticket in Azimio la Umoja, Raila Martha Karua, and now they may not be there. And civil society will want to push an electoral reform. What is the ground? If the Supreme Court already told the country that IBC technology take, this take. So where is the ground? Where do someone get the momentum to even run an election reform movement? And that is why I say that while it is, I am not in contestation of William Ruto's win, but what is in contestation is the fact that we did not offer an avenue on the platform. And of course, we are waiting for the full verdict after 21 days. But just into what it was done, sensational, hot air, goose, I think we did not question while there were real issues to be looked at. And this lack of electronic system scrutiny is a catalyst of election fraud. And so when Mutanguni tells you that the Kenya Kwanza government can reign for 10 years, then when William Ruto exits the space, they bring in someone from Game and takes charge, and after the Game of person, William Ruto takes charge, someone from Rift Valley again takes charge. You cannot be shocked, because unless such things are not addressed, unless we don't address this, then the truth of the matter, and if you talk to election experts, you'll be told that Kenya is not yet ready for an electronic system. This, if it is not audited well, and the real issues not addressed, This will be replicated in other African countries. Museveni will use this in Uganda, next general election. And who knows who will pick it next, and will use this as a model to perpetuate the rule against the rule of law. But I don't want to blame judiciary, because perhaps, and it's important to mention that this situation underscores the arbitration role of the Supreme Court. And someone can ask, or rather of the judiciary, and someone can ask, do you think it will be easy for someone to go to the court next time? Will there be that motivation? Or will there be that push that when I go there, they're going to listen to me? It seems you can only be listened to if you carry the forms of forms that this one and I think something that we as a country must appreciate is even rigging has to evolve. It is no longer about the forms of A not tallying with forms A, because the country is evolving and even technology is evolving. If you don't arrest this situation, I still stand that something will go wrong and big dreams will be shattered. It's time for the civil society to swing into action and perhaps seek these answers and push for election reforms. There are a lot of reforms that are needed, and time is ripe for Raila not to do it so that someone else can do it. There is no need of now pushing it. He pushed it, and the same system that he really worked hard to put into place after 2007 screwed his back. And that's my bold analysis.